Good evening, viewers. Tonight, we're diving into a story that's making waves from Austin to Silicon Valley. We're joined by a man who's not afraid to take on the tech titans in the name of election integrity, Texas State Senator Bryan Hughes. But before we bring the senator in, let's set the stage with the crucial piece of testimony that helped ignite this firestorm. Just a few months ago, Zach Voorhees, a former Google employee turned whistleblower, appeared before the Texas Senate Committee on State Affairs. His words laid out a roadmap for exposing big tech's alleged manipulation of information. Let's take a look at this clip.
What recommendations would you have for this legislature to take action to address the issues you address?
My recommendation is subpoenas would be filed against Google for any documents that have the name blacklist.txt related to Google, YouTube, and their news search corpuses. I would also ask that you subpoena their documents related to rankings of media outlets. I've provided a supplemental showing a slide deck including such a list. That is 4 years old. It's a bit dated. The open question now is, what are the updated rankings of the media outlets that they have? Also, machine learning fairness is so huge. I don't even know how you would even swallow that. But if you could do, ask them, file a subpoena, ask them for documents related to machine learning fairness. And that is going to be such a huge bombshell that it just needs to get into the public disclosure. So it's those three things: machine learning fairness, blacklists, and their media rankings is the start of the entire. What might be a really cheap way to get at this information is to ask what the decision process was for demonetizing Next News Network, right? Like, they're very large, and if you can get that information related to that case, I think that that's going to sort of illuminate what their decision-making processes were for that demonetization. Like, they're still demonetized. They've been demonetized for like 6 months, like the top conservative news network on YouTube. And the question is, why did they get demonetized? And if we have the answer to that, we're going to get the answers to a whole bunch of other censorship activities with the company.
And those are questions we hope to get today, because that explosive testimony you just witnessed wasn't just another day in the Senate. It was the spark that lit the fuse of a Texas-sized investigation into big tech's influence on our elections and public discourse. Now, fast forward to August 8th of this year. Senator Bryan Hughes, the chairman of the Senate Committee on State Affairs, he fired off a letter to Alphabet CEO. And this wasn't just another strongly worded message from a politician. It was a formal document request demanding information about Google's potential role in election interference. And it came with teeth: the threat of subpoenas authorized by a unanimous committee vote. Senator Hughes isn't just talking about election integrity. He's taking action that could change the game forever. From algorithms to content moderation, from blacklists to so-called machine learning fairness, he is demanding answers on how big tech might be shaping our political landscape. But the story doesn't end with Google. Similar letters went out to Meta, TikTok, and X, formerly Twitter, and the clock is ticking and Silicon Valley is sweating. So tonight, Senator Bryan Hughes breaks his silence on this high-stakes showdown. He will reveal the strategy behind this bold move and the specific documents he's demanding, and what he hopes to uncover. Will also get his take on the recent bombshell admission from Mark Zuckerberg to Congressman Jim Jordan. Did Texas actions force Zuckerberg's hand? As other states watch closely, Hughes will explain how this Texas-sized investigation could spark a nationwide pushback against big tech's unchecked power. So get ready for an explosive conversation that could change the way you think about your search results and social media feeds. Senator Bryan Hughes, welcome to the show.
Thank you for having me, and thank you for bringing attention to this matter that affects every American.
Well, Senator, I commend you for going after these tech titans. It's something that is long overdue. Now, it's been nearly a month since you sent that letter to Alphabet. Let's just get right to it. Have they responded? And if so, what did they say?
So after the letters went out, we heard from each of the firms, some from their lawyers, some from in-house people. They all said they wanted to cooperate. And we said, well, you can cooperate by providing these documents that we're asking for in the letter. Otherwise, we'll have to take a further step. And as of Friday noon, that was the deadline we gave them. We've received a lot of documents. Now, we don't think we've received everything. And as you can imagine, it takes a while to go through that. We have some technology to help us go through that. So we're going through the documents now. We've heard from all but one of the firms, and they say they're going to have something for us today. We don't know if they're testing our resolve. I don't think we're serious. We're serious, and the subpoena power is there, ready to go if we need it. So we did receive a lot of documents. That was encouraging. We're in the process of going through them now.
Now, are you at liberty to tell us who has not yet responded but said they would?
The one firm that did not produce documents by Friday was Meta, Facebook. Again, they've spoken to us. They've been responsive, but they didn't get us the documents, and they knew the deadline. We reminded them about that. Now, they've indicated they'll have something today. That's the last word I got before going on. So hope so. If not, then we'll see them at the courthouse, and we're ready to do that. We're actually very excited about doing that.
Now, specifically Google and YouTube, that's really my primary focus, as of course my channel was mentioned in that hearing. Have they been completely transparent? Do you feel that they're lacking? They're not showing all the information?
This was their initial production. They say there's more coming, but we're not going to give them forever. So we're going through the documents we have so far, and our requests were very clear, and those specific things you mentioned were included, of course, from the testimony we heard at the committee. Also, Dr. Epstein's testimony about how Google will remind you to register to vote if you're a Democrat, a lot more likely to get that recommendation than if you're a Republican, and how Gmail has been sued for blocking Republican emails, sending Republican emails to spam, but letting Democratic emails go through. We're talking about objectively verifiable things, not just vague notions. Obviously, how they decide who to demonetize and why. We want to know about that when it involves this political speech, which is so important. People go to these sources, people trust these sources, and when they say, we're unbiased, we're just a clearinghouse for information, we're not trying to sway things, okay, well, let's see if that's the case. Let's find out. We want to peer inside the keyhole and see what's going on inside there.
So do you think subpoenas will be necessary to get the rest of the documents, or are they going to comply?
We hope they won't be necessary. This subpoena power is rarely used. We do have it. A couple of years ago, we used this with BlackRock and some of those financial firms who, through ESG, were taking Texas money and then using it against us to shut down energy production and to kill jobs. In that case, we requested information from 4 firms. 3 complied. Only 1 had to be subpoenaed. And so we'll see what happens here. Texas is a big state, and our committee can hold its hearings anywhere in the state, and our subpoenas have statewide jurisdiction. So this hearing will not be held in Austin. We won't be in front of an Austin judge. It'll be somewhere else in Texas, and we're confident it's going to be a place where the law is going to be followed and where they're going to be held accountable.
Yeah, that brings me to a question I brought up with Daniel Cochran when we interviewed him just a couple of weeks ago, because one of my main concerns was that, well, Google's going to go and venue shop, they're going to try to find a friendly judge or somebody so that they can push back on these things, but you guys have the sole jurisdiction and essentially are pulling them in to the venue of your choosing to get the answers that you need.
That's the plan. Of course, who knows what they may file, what kind of delay tactics they may try to use. But the place where they'll be ordered to produce the documents by the subpoena will be in a place where we are confident and prepared to move forward, confident we have a court system that's going to follow the law and, again, hold everybody accountable. That's all we need.
Now, you mentioned not in Austin, and why is the reason for that?
Well, Austin's a great place. Our capital is so beautiful. We really enjoy having hearings there. We do have the authority to hold hearings anywhere in the state. And again, these subpoenas have statewide jurisdiction. And so many times in our urban areas, Texas is no different, politics can have an effect on the judicial system, right? Mm-hmm. And on who gets treated what way. So
of course,
we'll be doing this in a part of Texas where politics will not be having any effect on the justice system doing its job.
Well, we've seen far too often in recent history how politics has affected the judicial branch. Of course, I'm speaking of the lawfare that's been levied against Donald Trump and his campaign for office. But let's go back to the letter, because in your letter you mentioned attached document requests, and you're going to peer into that keyhole. And what do you intend to find? What do you think you're going to find in that keyhole with those document requests? What were some of those specific requests, if you're able to disclose that?
We want to know how those decisions are made. When you were dealing with political questions and how you treat a campaign, how are those decisions made? You rank news sources for reliability. Well, that's pretty subjective. We'd like to know how you're making that decision. And again, we want to know why partisan emails from one party get through and partisan emails from the other party get blocked. So simple, verifiable things like that. Also, the process for demonetizing. Our experience has been when somebody gets punished for their speech and we complain about it and we find our way to the right person at one of these huge tech companies, they say, oh, yeah, sorry, that was our algorithm. We'll get that fixed. They hide behind the algorithm. Well, that's not going to work. Someone programmed that algorithm, or something was fed into the AI with that algorithm. We want to know what it was. And that's really all we're talking about. To the extent that these are human beings that are making these decisions, where are they? Who are they? How are these decisions being made? Because these affect every American. And so we have to know what's going on.
Well, this channel, we reach millions upon millions of people across the world, millions of people in the United States every month. And we've been demonetized for the last 20 months or more. We were given vague answers as to why. They point you to a list of terms of service, and you have to kind of go through this needle in a haystack to figure out what exactly it was. Now, over the course of 20 months, Senator, we have gone through, I think, 5 or 6 reapplications, and every single reapplication has been denied. And then you have the opportunity to appeal that decision, and those appeals get denied. And every time they just say, look at our terms of service, your news content is harmful, yet we don't really understand who's being harmed by the content that we're producing. And in the result of that is we've had to fire 99% of our staff, and we're on the edge of bankruptcy, and we've had to delete. We've had to go through every subsequent reapplication. We have to find the needle in a haystack. We have to go through keywords and searches and try to think about what it is causing this. And in the process, we've deleted over 30,000 videos, over 10 years of my work on this channel, and over 1 billion views. So there is a direct impact, not just on the information that's out there, but real lives that are being affected by people that don't give you straight answers to these different appeals and reapplications. So once these documents, you have them, what do you plan to do with them? Will they become part of the public record? Is this something that the average American could go through and review and make a determination for themselves?
The process you just described, where you are required to prove your innocence, that's bad enough, but they won't even tell you what the standard is. That's got to be frustrating. And that's how everyday Americans feel when they get blocked. But in your case, so many people are affected. So here's what happens with the documents. The Texas Open Records Act says that government records are open. And so the default is anything we obtain is subject to open records. Now, of course, there are exceptions. If something's a trade secret, if it's proprietary, sensitive information, of course, that is protected. But the assumption is this information will be available to everyone. And that's part of why this is so important. So our plan is to obtain the documents, go through those carefully, and we have our own team plus some outside counsel helping us do this. I've done some of this in litigation, but this is a big project, so we need many hands to help us. So going through those documents, and then this is in preparation for a hearing. So in addition to the documents, we can subpoena people. So we'll be having another hearing of the committee between now and the election, where we'll call live witnesses to give an account, to answer these questions. Many of the questions will be based on the documents that they produce or documents that we obtain other places. Sometimes stuff on their own websites is helpful. And they'll be answering questions along these lines. They'll be under oath. Many times these witnesses are accustomed to congressional hearings, which are very effective. I enjoy watching them, and we learn a lot. But normally those congressional hearings, each member of the committee has a few minutes, and they're kind of in and out. In this hearing, the witnesses will be here for a long time because they're going to have to answer questions. And when they give us answers, we're going to follow up on those answers. So it'll be a thorough hearing under oath to get to the truth.
So are we talking like the CEO of Google, the CEO of X, Elon Musk? Are we talking about, or are we talking about just some of the lesser employees, the engineers, people who may be making these decisions? And some of my thought process behind some of these decisions on my channel, how high up does it go? Does it go all the way up to the CEO of Alphabet? Does it go up to the CEO of YouTube? Does it go up to, just a mid-level group that makes these determinations, and it never really gets higher than that? Who do you envision perhaps being pulled into some of these hearings?
Well, that's part of what we want to find out. In the case of the financial firms, we had very high-level people answering the questions. Our goal is to have the persons who are making these decisions, to have the deciders be the ones answering the questions. And so that's what we're going to try to figure out between now and the time of the hearing. We believe these documents will tell us a lot about who's involved and what did they know and when did they know it. That's what we want to find out so we know the right person to bring. So stay tuned for that, but we expect it to be meaningful testimony from someone from each of these firms who has decision-making authority.
Yeah, a lot of times YouTube gets kind of looked over, passed over when it comes to the social media landscape. A lot of times they just want to talk to Google, they want to talk to Facebook, they want to talk to X or Twitter, but YouTube is often overlooked. And I don't think we've ever seen, even in congressional testimony, the CEO of YouTube ever pulled before a congressional federal hearing. So this would be really interesting to see if that actually occurs. But so often what happens when you have somebody so high up, they usually just defer to, well, we'll have to get back to you on that, right, because that was done by this group. So let me get back to you, and that's the end of that line of questioning. So how do you plan to get around that?
That's the problem often in litigation. You can take the deposition of the CEO, but the CEO doesn't really know the answers to these specific questions. Mm-hmm. Our experience with financial firms was one firm sent someone that pretty much gave us the party line and wasn't involved in making the decisions. But two of the other firms that we went after sent a witness who was involved in the decision-making process, had authority, and we really had a meaningful discussion with those folks. So that's what we're going to shoot for. And, the American people are going to be watching this. And so if a firm decides to send someone that doesn't know anything or says they don't know anything, that's going to tell us a lot.
Now, recently, Mark Zuckerberg, he sent a letter to Congressman Jim Jordan admitting some controversial content moderation decisions. It came right around the same time as the deadline on your letter. Do you think that your actions in Texas may have influenced this admission from Mark Zuckerberg?
Oh, it's very kind of you to suggest that. We don't want to assume that, but we'd love to think that we have a small part in this. We have heard from friends around the country that this may be having an effect, and some people who had been blocked are now back online. And that's our goal. We want to shine a light on what they're doing. We believe if we draw attention to it and people are paying attention, these companies will be less likely to do these things. So that's the goal.
Yeah, we did hear that as well, that there were multiple YouTube channels that you would never have thought would return to YouTube after a series of different purges that YouTube had gone through. Suddenly, their channels were restored overnight, and of course, we have yet to reapply for our monetization yet. We're just kind of waiting in the wings to see how this process plays out with your committee and these letters. Now, if the companies fight the disclosure requests, I mean, you said they've been pretty cooperative thus far. What happens next if you don't feel like they've been completely forthright with you? You said maybe they didn't give us everything here. What happens?
So under the law, these subpoenas are backed up by the power of contempt. And procedurally, we send the subpoena. They don't respond. They're recalcitrant. Then the Lieutenant Governor of Texas, who presides over the Senate, takes the matter to the Texas Rangers. The Texas Rangers then take it to the district attorney, who goes to the grand jury. And if the grand jury agrees with us, they didn't comply, then they're fined. And the fines run on a daily basis, and they add up. So this is serious. We're trying to be polite. We're trying to work with them and not go right to DEFCON 1, right? If we hope a carrot will work, won't have to go to stick. But we're doing this on behalf of the people of Texas. That's serious. We take it seriously, and these firms would be wise to take it seriously as well.
Well, you mentioned the Texas Rangers. I don't think I would want the Texas Rangers coming after me. But so how do you respond to critics who might say, you know what, this is government overreach into private business? How do you respond?
These firms control so much, and I'll take two tracks here. First of all, for all intents and purposes, these firms are common carriers. You know, Justice Clarence Thomas has written about this. He believes that way. A number of Supreme Court justices believe that. We're going to find out on our House Bill 20 litigation how many of them believe that. But as a practical matter, these big social media platforms, this is the new town square. It's where people go to get their news. It's where people go to hash it out, to have a debate, to have a discussion. They are common carriers. And so just like your telephone provider can't cut you off because they don't like your politics, right? Your natural gas provider can't deny your service or raise your price because of your religion, because they're common carriers. And this has been recognized in Western civilization for a long, long time. They control so much and people rely on them so heavily, and they're the only game in town. There's no place else to go. So it's appropriate to hold them accountable as common carriers. But beyond that, let's talk about consumer protection. If you are selling a product and you say, my product does X, Y, and Z, and it doesn't, then you are liable in a civil court because that's misrepresentation. You've told us it's something it's not. When these firms say, oh, we're open, we're an open platform, and we don't discriminate, we don't have a political bias, if you say that, we are going to hold you to it. So on multiple bases, we have an appropriate public interest in making sure they're not cheating.
Well, in my case, it's going to be interesting to see, how much they actually disclose to you, because I would like to know what type of biases they're putting forward with respect to keywords or ideas or even specific videos, because I can't get answers to those very questions. And the common carrier point you bring up has been made dozens of times by many people, and I think it's a really strong argument. How do you think they'll respond if they are then regulated as common carriers?
They'll be treated like anyone else in that situation would be, and they have to treat everybody the same. They can't discriminate against you based on your politics, based on your religion, based on your view of health care. My goodness, things that people have become so frustrated on YouTube, for example, when they get blocked because they express an unpopular position. You know how free speech works. We don't need free speech protections for popular speech. The market takes care of that. Free speech is there for the unpopular speech, for the minority speech, because in America, we're not afraid of a debate. Free speech has many practical benefits. If I'm wrong, I want to know about it. Tell me what you think. She'll tell me what she thinks, and we'll hash it out, and we'll get to the truth. And the marketplace of ideas will work. But today, we have a handful of San Francisco billionaires that have made themselves the gatekeepers. They have a stranglehold on the discussion, and only one side gets through. And that's not right. Whether it's right or left, we need to have a discussion, have a robust debate. And that's what this is about.
So this is a perfect segue because I want to get your reaction to a statement made by Vice President Kamala Harris about regulating social media platforms, calling for increased oversight and regulation. Let's watch.
He has lost his privileges and it should be taken down. And the bottom line is that you can't say that you have one rule for Facebook and you have a different rule for Twitter. The same rule has to apply, which is that there has to be a responsibility that is placed on these social media sites to understand their power. They are directly speaking to millions and millions of people without any level of oversight or regulation. And that has to stop.
So your investigation into big tech also seeks a form of oversight, but with the aim of ensuring more open and free speech on these platforms. Explain the fundamental difference between your approach and what Vice President Harris is suggesting. How do you respond to her characterization of free speech on social media as a privilege rather than a right? And how does your investigation aim to protect the First Amendment rights while also addressing concerns of big tech's influence on public discourse?
I am so glad you asked about that. Here's what we're not doing. Here's what Texas is not doing. We're not setting up some agency to approve or disapprove what social media can say. That's not what we do. This inquiry is about finding out what's going on. This is about disclosure. If I'm treating Republicans one way and Democrats the other way, I'm free to do that, but I need to disclose that. I need to let people know. Don't say you're unbiased and you're open if you're not. This is about disclosure. House Bill 20, which has come up once or twice. Texas passed this bill in 2021. I was the author of this bill, and it was aimed at individual users. And it says, Facebook, big tech, if you demonetize me, deplatform me, block me, put me in Facebook jail because of my speech, then I have a recourse in the courts. I can go to the courts, and if I can show that you blocked me because of the exercise of my speech, you've got to put me back online. You got to pay my attorney's fees. It's between the user and the platform. As you know, American courts have been working on First Amendment free speech for a long time, for a couple of centuries now, and that's where it should be. We are not talking about putting some government agency in charge of what they can say and what they can't say. Not at all. The answer to bad speech is more speech, not enforced silence. The vice president's calling for speech police, calling for the feds to say what you can say, what you can't say. We're calling for more speech, even speech we disagree with. The Supreme Court got that right in that concurring opinion decades ago when they said the answer to bad speech is more speech, not enforced silence. Let's get all the ideas out there, all the viewpoints out there, and let people make their own decisions. I'm so glad you mentioned that. We are not pushing for what the vice president's talking about. She has a fundamental misunderstanding of free speech.
Now, I want to get to the House Bill 20 in a second, but how do you think this investigation by Texas could impact other states or even federal policy regarding big tech and election integrity? Are you in contact with other state legislatures about the issue?
We are. As you know, states have a lot of power. The way our founders designed this, the states are where the power is, and the states have given a little power to the feds, but they've kept most of it. Of course, over the years, the federal power has grown and grown so that now we think of the feds as the primary responsibility. But the states have a big part here, and big states like Texas, because we're a big enough market, if we were our own country, we would be the 8th largest economy in the world. And so when a state like Texas takes action, these firms have to respond. And when they make changes because of what Texas requires them to do, it has the benefit of helping the rest of the country. But yes, many states are looking at this, and many friends at the federal level as well. As you know, Congress is moving kind of slow these days, and we're thankful for Congress, and we're hoping that there are more conservatives elected there this year, but Congress moves kind of slow. And it's often hard for them to move. In the states, we can be nimble, we can be responsive. And so Texas is trying to lead on this.
Now let's talk about this complex legislative and legal landscape that's leading up to your current investigation. April 2021, your colleague, Senator Lois Kolkhorst, introduced Senate Bill 1158, addressing social media companies unjustifiably censoring political speech. Then, September 2021, Texas enacted House Bill 20. You introduced the bill, the Texas Anti-Deplatforming Law, aimed at prohibiting large social media platforms from moderating content based on viewpoints. Now, this bill faced significant legal challenges. I've been tracking it. It was initially blocked by a U.S. District Judge and then temporarily reinstated by the Fifth Circuit Court of Appeals. However, the Supreme Court intervened, suspending the bill pending a review. Then the Fifth Circuit Court later reversed the injunction, but again, a stay was granted following an appeal to the Supreme Court. Now, given this complex and evolving legal situation, if your current investigation uncovers evidence of election interference by big tech, what kind of legislation action might we see from Texas, and how do you plan to navigate these legal challenges and potential Supreme Court scrutiny in your efforts to regulate big tech's influence on election and public discourse?
This spring, I was at the U.S. Supreme Court for this argument on House Bill 20. It was our bill. We wanted to be there. It's the second piece of our legislation we've had the honor of seeing at the U.S. Supreme Court. And so we wanted to be there for the arguments and met with some legal scholars and folks who were supporting us while we were there. And here's what I said at the time. If the Supreme Court decides to block this law, then we'll be back with another one. We'll carefully read their opinion, and we'll pass another law that addresses this problem. Texas is not going to stop. The power that big tech has growing over time, and it's not going anywhere else. The power that they have over our lives, the power that they have to shape the public discourse. And again, to pick winners and losers, this is not going to go away. And so we were pleased that the Supreme Court sent the bill back to the Fifth Circuit for some further proceedings. And one of the best things said so far was coming out of the Fifth Circuit about House Bill 20. And they said this: the First Amendment does not grant these platforms a freewheeling right to discriminate. Here's what's frustrating. These big tech platforms, common carriers for all intents and purposes, have so much control, which they are using to squelch viewpoints they don't like. While they do that, they want to cloak themselves in the First Amendment. No way. That's not what the First Amendment's about. When they have this kind of power, often given to them by the government, and as we learned, often in bed with the government. As you know, there was another case before the Supreme Court about where the federal government worked with Facebook to silence certain speech, political speech, just because the current administration in office at the time didn't like that speech. We can't have that. That's not what the First Amendment's about. So we're optimistic. We're optimistic on House Bill 20 that now that it's back at the Fifth Circuit and the case moves forward, discovery is going to take place. What do I mean by that? You know how a lawsuit works. A lawsuit's filed and both sides can ask the other side's questions, and they can say, show us your documents. Big tech sued us immediately when House Bill 20 was passed because they did not want to go through the discovery process. Mm-hmm. They are scared to death. They're scared to death of the American people seeing what they've really been doing. Once we open up the books, once we shine a light and see what they've been doing, there's going to be a reaction.
Well, and that's exactly what your letter is about to uncover, is that through the subpoena power of your committee, you're basically getting that disclosure, that discovery process immediately. Now you can take a look at it and you can go, okay, we got House Bill 20 here. We know exactly what they're doing now. Now we can fine tune our legislation to bypass the arguments that were made previously by the different courts. We can really hone it in with all this information. Am I grasping that correctly?
So I'd say the focus of this inquiry is, of course, on election integrity, election interference. So it's a little bit narrower than House Bill 20, which had to do with all political speech. But yes, you are correct. We have this legislative authority under the Texas Constitution to seek this information. And you bet it may very well be that some of the information that's eventually going to come out in House Bill 20, we may get some of that information We may get some of that information now. We're sure hoping so.
So when you get that information, do you intend to write new legislation to prevent any abuses that you may discover in that?
We don't know what we're going to find. This is a two-part process. The primary purpose of this investigation is to shine a light. Let's find out what's going on. It's been well said. You're a First Amendment guy. You're in the First Amendment business. Sunlight is the best disinfectant. When people see what's going on, that's more than half the battle right there. But depending on what we find, it may be we need to come back with some more legislation. That's a possibility as well. Our main goal is just to shine a light.
So to shine that light, you get the documents, and someone like myself who definitely has an interest in reviewing those documents, how would I go about securing them through the Texas Public Records Act?
So anyone can file an open records request. In the case of our inquiry with the financial firms, we had a number of members of the media send open records requests right away. We're not coordinating any of that, but I wouldn't be surprised if that happened again. So again, if documents are privileged, if it's a trade secret or it's something proprietary, that will go to the Texas Attorney General's office to determine. But other than those documents that are protected from disclosure because they're proprietary trade secrets, other than those things, this information will be in the public domain sooner rather than later.
So I assume that once they know what they're giving you, and now it's going to go to the Attorney General to review it, but the Attorney General's perspective and those corporate CEOs' perspectives could have very different ideas of what's trade secret and what's not. So how does that argument get solved in the public interest?
So under the law, the Attorney General makes that decision, acting on behalf of the people of Texas, again, to follow the law. If they don't like the decision that the AG makes, there can be litigation over that. But we believe if this is done fairly, there will be some documents that are truly proprietary trade secrets, and we're going to follow the law. We believe without those documents, there is plenty that we're asking for that will open up and give us the information we need for this inquiry.
Now, looking ahead to the 2024 election right around the corner, how do you think your actions might be impacting big tech's behavior in these next coming months? You think that they'll, as Daniel Cochran has written recently, make these platforms more neutral in these coming months? Or will they just go back to business as usual?
We want them to know that we are watching. People are paying attention to this. We want them to know that. And accountability is always good. If you know someone's looking over your shoulder, if you know people are watching, you're more likely to do the right thing. So that's our hope. Our hope is that by shining a light on what they're doing, it will discourage them from cheating, from misguiding people, from being unfair in the way they operate their platforms. That's our hope.
Well, Senator, I want to thank you so much for taking your time to join us here on the Next News Network and for spearheading this cause, because free speech is paramount. Some people want to restrict our ability to speak, and you just want more voices. And the more voices we have, the better decisions we can all make. So again, I thank you for joining us, and I look forward to tracking this story as the information comes out. Before we go real quick, you said that you're expecting some more disclosures today. When do you expect the final disclosures and your final decision on if you've received everything you've asked for, and if you do need to go ahead and issue any subpoenas? I mean, how much more time, days, weeks, do you think is going to unfold even after this deadline has passed?
So our plan is to hold the hearing between now and the election at a time that's meaningful during election season. So if you think of that as the bookend, we're going to back up from there. So we're going to make sure we have the documents and plenty of time for that hearing. So we're talking about days to weeks, not months. This is going to move very quickly.
Wow. Amazing. Well, I will be following it very closely, Senator. Thank you for your time.
Thanks for having me on.
And there you have it, folks. Senator Bryan Hughes laid out a bold vision for holding big tech accountable and protecting the integrity of our elections. Now, this is not just a Texas issue. It is a battle for the soul of our republic in the digital age. As we've heard tonight, the stakes couldn't be higher, with potential subpoenas looming and legal battles on the horizon. We're witnessing history in the making. Will other states follow Texas's lead? Will this force big tech to change its ways before the 2024 election? Will we get remonetized? Well, one thing is for sure, this fight is far from over, and Senator Hughes has thrown down the gauntlet, and Silicon Valley is on notice. As voters and citizens, we all have a stake in this outcome, so keep your eyes on Texas. America, the Lone Star State, might just be leading the charge in redefining the relationship between big tech and our republic. The digital revolution is here, and it's being televised.